Legal 110, this is your podcast for week number 3, where we will be discussing and exploring sources of American law, the court system, and the two sides of the courthouse, criminal and civil. I'd asked you to do some pre-podcast reading, and if you haven't done that, go do that. And then after you listen to this podcast, there are some other tasks that I've asked you to complete over this week. Much of what we will cover this week, you should have learned. You should know this. You actually should, at least by law, you were supposed to have known a lot of it by the time you finished grade school, and then again high school. You probably remember taking various forms of constitution tests, is what they commonly referred to as. But those tests and that focus is really on you as a citizen of the United States having a basic understanding about our government, our form of government, the way that our government works, and our legal system, our laws, constitutions, statutes, cases. You should have had some exposure to all of that. You should have had an understanding of how you will interact with, and many of you have been interacting with, because you're maybe not right out of high school, right? The world through the legal system, and I'm going to focus on the legal system. So what is the law? There's all sorts of definitions you might find, but in general it's defined as a body of rules of conduct established and enforced by a government. Now that can be, in our case, the federal government. It can be the state government. And it can be a whole bunch of local governments, counties, cities, villages, school districts, the sanitary district, some of which are true elected form governmental bodies, and some of which are administrative bodies. And then we'll find administrative bodies, administrative agencies, and government functions from the local level all the way up to the federal level. Talking about Environmental Protection Agency, both at the state and the federal level. I'm talking about if you work in the restaurant, food service industry, you're well aware of health department expectations, right? All sorts of regulations. You drive a car. Driving a vehicle is a privilege, not a right. It's a privilege that is subject to administrative regulations through the Illinois Secretary of State's office, because that's the body that licenses drivers. So that's what we're talking about. Laws establish rights, duties, and privileges for the citizens that are governed by whatever that body is, that governmental body. If it's a local body, well, if you live in the city of Peoria, the city council for the city of Peoria dictates city ordinances and expectations. If you live in Pekin or East Peoria or the village of Peoria Heights or wherever, they will dictate certain obligations, duties, rights, privileges of citizens who live within that geographic area. Same between states, and then, of course, between countries. We need law. I've been involved with the law for a long time. A long time, since before I was 21 years of age. I started studying it before then, and I started serving it at 21. the thing that attracted me to the law, that caused me to have a passion for working with and serving other people through the law, is that the law provides stability. It provides predictability. It provides continuity. It helps us have expectations. And while we often see on social media or hear in the news a whole lot of talk about maybe being overgoverned or having too many laws, and in some respects we may, we also know that if we did not have those expectations, people, being humans and human nature, would result in people exercising their freedom. And when I say freedom like that, freedom, I'm making the air quotes, in such a way that it does not allow for stability, predictability, and continuity, and in fact infringes on the rights or privileges of other citizens. We need laws. We need to be able to say that if you're driving on a certain roadway, you should drive at a certain speed limit, not 120 miles an hour. Some of you will, at some point in your careers, deal with the loss of human life as a result of the unreasonable actions, sometimes intentional actions, of another human. And that's the worst case scenario. But in between, you can have people that lose the ability to drive their vehicle because somebody was driving unsafely. They crash their car into your car. And now you don't have a vehicle and you're inconvenienced, and hopefully you had insurance and they had insurance and you get a replacement vehicle quickly or get your vehicle repaired quickly, but you're inconvenienced. And if you were injured, hopefully not severely, but what if you were? Or what if you were injured in a way that wasn't severe, wasn't life-threatening, but you forever will have some sort of limitation, some sort of pain, some sort of recurring situation with that incident. So the law provides stability, predictability, continuity, expectations. It provides rights, duties, and privileges. We need the law. And I suspect that if you're in this class, if you haven't decided that you believe we need the law, you may be leaning that way. Let's talk about sources of American law. Now, you'll hear different numbers thrown out. I think historically we believed that there were three types or three sources of American law: the United States Constitution and state constitutions. The constitutions of the United States and states' constitutions provide the framework for all other development of law, both the courts and legislation, ordinances, etc. And then there's statutes or ordinances, if you're talking at the municipal or local level. That's that body of law that attempts to tell us what our rights, duties, or privileges are regarding a certain thing, whatever it is that the government's trying to address. And go back to the example about driving a vehicle, expectations for someone driving a vehicle on the roadway, etc. And then the third one traditionally was case law or common law. law that comes from the courts. Now, the courts came before constitutions and legislation. Historically, we adopted the English common law. The English common law was court-created law. Courts came up with, for instance, those of you who are in my criminal law class or have had it, if you think about assault and battery, the elements of assault and battery, as set forth in the Illinois statutes that define those things as crimes when committed by someone against a citizen or a person in Illinois, those came from English courts a long, long time ago, from the common law. A battery, as defined by the common law, was an intentional, unpermitted, harmful, or offensive touching of another. It wasn't you popped them in the nose with your fist, or you hit them with something, or harmed them with a weapon. And if you've had criminal law, you know what I'm talking about. And if you don't have it now, or you'll have it in the future, you'll know what I'm talking about eventually. But those were the three. At some point in the United States and globally, different levels of regulations from government agencies or local bodies of government primarily started to surface. In our country, we typically subscribe to the history of federal agencies being formed. Federal agencies in the United States were formed at the early part of the industrial age, when we started to do things like process meat in factories. When we started mass producing things, when we started to have factory labor. And two things happened there. Number one, concerns over safety of people working in factories became a concern. People were dying, getting injured, getting harmed by unsafe work conditions. And when we were mass producing, food or other items, the expectation that those items were edible, safe, etc., became a concern. In other words, you didn't want to buy something that had been mass produced and then get sick and die from it, or get harmed because it was produced to save a buck, or in a way that saves some money. So, as an example, or a couple examples of that, if you take administrative law, you'll probably come across this particular example. In the Chicago packing houses, where they were mass slaughtering and producing meat products from cattle and hogs, and primarily cattle and hogs, there were incidents where someone's finger or parts of their hand were lopped off in the process and just left in the meat. I can probably almost see some of you cringing. Imagine you went to the Hy-Vee, the Schnucks, or the Kroger, or Aldi, or wherever you go to get your fresh meat. You buy a roast for dinner. And this was probably more in like a sausage or something. Parts of somebody's Digits were in there. I mean, come on, right? So there was that part. So these agencies were developed, and they had regulations. Okay, they had regulations. Now, still today, we see that despite regulations and despite expectations, and regulations are pulled back, agencies' funding is limited so they can't really police industries, and catastrophic things happen. Second example I'll give you, and then I'll move on from regulations. Ford Motor Company at one time produced a vehicle called the Ford Pinto. It was a small car, two-door hatchback. It was cheap to produce. It was cheap to buy. A lot of younger people ended up with that vehicle. It had an aluminum block engine. I had one. For every 10 gallons of gas I would put in that vehicle, I had to put in 2 quarts of oil. There were times when there were no mosquitoes within probably a 5-block radius of my house because that vehicle smoked so bad that it killed them all. I was like Mosquito Joe in the 80s. The Ford Pinto, from the rear, if you were driving behind me, you could see right up under the rear of the vehicle, and you could see the gas tank. It was angled upward from the wheelbase towards the rear bumper. Now, I didn't know this at the time I was driving the vehicle. I knew it much later as a lawyer when I got a hold of the case. But 5 college students in Indiana are traveling in a Ford Pinto just like the one I owned back in part of my college days. And I say part of my college days because it's such a crappy car. I had several crappy cars during those days. These poor kids, though, were traveling down the roadway. They were rear-ended, and the vehicle exploded into flames. They were burned to death in the vehicle. The cause of that catastrophe, of course, there was the fact that they were rear-ended, right? But the real cause was this. On the other side of the gas tank was this bolt that served some function. And the engineers recommended that Ford spend 5 cents per vehicle on this cap that would go on the bolt, which would prevent the bolt from puncturing the gas tank in the event of a rear-end accident. Ford refused to spend that 5 cents. That's why we have administrative agencies. That's why we have all these regulations. It's not to make things more expensive. It's to make things safer. Now, can there be overkill? Possibly. But just so you know, that number 4 of our primary sources of American law, regulations, there's just some examples of why that's come to be. And then there's actually a 5th category. Treaties with other nations. Treaties with other nations. Agreements with other nations. Government to government. So in other words, the primary sources of American law, any government-created thing, document, law, ordinance, statute, regulation that establishes rights, duties, and privileges for the citizens that that entity governs. So those are the primary sources of law. And again, you're going to have plenty of exposure in other courses to those very sources. Let's talk about going to court. Some of you may have gone to court already. Some of you may go to court in the future. Very few people end up not having some sort of exposure, either directly or indirectly through family or friends or jury duty or something like that, with the courthouse and courtrooms. To go to court, we must have standing to sue. Standing to sue means you have a sufficient stake in whatever it is you're going to court for or being brought to court for. You're connected to it. You have a legally protected, genuine interest. If you're the person seeking relief, you have to have suffered some defined harm. Now, sometimes you can sue on behalf of another person, and there's usually some sort of legally recognized connection there. So you're the guardian of a child or a disabled person, as an example. And then there must be a controversy at issue that must be justiciable. I can hardly say the word. Which means that the court must be able to decide it. And that controversy has to be real and substantial. It can't be hypothetical. It can't be academic. It has to be recognized. We have statutes and regulations that tell us, and our constitutions that tell us what are the things that may be controversies at issue, things that we can go to court on. The other thing you must have, the court must have jurisdiction over that case. There's different types of jurisdiction. In Latin, juris means law, and diction means to speak. Courts must have jurisdiction in order to hear a case. Now, courts either have jurisdiction over the persons involved in the case, or they have jurisdiction over the property in the case, or the subject matter in the case. Now, they have jurisdiction over the persons because a statute or the Constitution says that they have jurisdiction over these people. They'll have jurisdiction over the property if the property is located within that state or jurisdiction, if it's federal, or of the subject matter if there's a statute that says it's the type of thing that the court can hear. And then there's two types of jurisdiction that we look to. There's original jurisdiction, which is the jurisdiction of the court that first hears that case. We typically refer to this as the trial court. And then there's appellate jurisdiction. And appellate jurisdiction applies to what level of the appellate court. And in most states and the federal level, we have an intermediate level of appellate court, and then we have the supreme, the top court. You also must file your case in the proper venue. Now, you can think of venue and probably think of venue in terms of the places you go to see a concert or sporting event or something like that. It's similar. It's the most appropriate location for a trial. Now, it should be in the geographic area of the lawsuit where the thing occurred, usually the county where that thing occurred, or at the federal level in the geographic area defined by the federal government or the court system, federal court system, as to which courts can hear certain things that occurred within that area. So venue, we're talking about the location, the geographic area of the things we just talked about for jurisdiction, where the property is located, the people are located, or where the court is given jurisdiction by a certain other statute or regulation. Now, there's some good maps provided in the textbook. To break out the courts and break out the federal courts and show what jurisdiction looks like. But I asked you to go to the Illinois courts page. In the Illinois courts page, provides you with some good guidance as to where you file certain things in Illinois. The federal courts, we have the Supreme Court and 13 appellate court districts, or circuits, I'm sorry. Yeah, we get really confused because in Illinois we call the intermediate courts districts. At the federal level, we refer to them as circuits. There are 13 appellate courts at the federal level, 13 circuits. Most are made up of multiple states. For instance, Illinois is in the 7th Circuit with Wisconsin and Indiana. Like many things, we divide things, our responsibilities of the federal government up into consideration of population. And then we adjust those. Sometimes we change those expectations. The trial courts at the federal level are referred to as district courts. When we get into the Illinois courts, and for those of you in legal research right now, you may have already gotten to this point, but it can be confusing. At the federal level, we refer to the intermediate appellate court as circuits. In Illinois, our trial courts are referred to as circuits. The federal courts, at the trial courts, we refer to them as district courts. In Illinois, we have appellate courts that we refer to as appellate courts of, and there's 5 numbered districts. So those terms can be interchangeable, and they're not only interchangeable regarding Illinois, but you'll find those terms interchangeable across the country. New York, for instance, refers to the trial court level as their Supreme Court. So it's all over the place. You just have to know, essentially, that there is a highest court. There is usually an intermediate appellate court, and there are trial level courts, and everything starts at the trial court. Now, on the federal trial courts, the federal district courts, some states have one district because that's just what their population dictates. More populated states like Illinois may have more than one district. Illinois has a northern, central, and southern district. All right, a northern, central, and southern district, and you can kind of, doesn't exactly flow with like this, but you can kind of picture like the part of the state that is north of I-80, Interstate 80, that cuts across from Iowa to Chicago. It's pretty much the northern district. The central district is south of I-80, and then a little bit south of Springfield, Illinois, and the southern district has the southern tip of the state, including the Madison, St. Clair counties on the suburbs of St. Louis on the Illinois side. Wisconsin, as an example, has an east and west. United States District Court for the Eastern District of Wisconsin, which would be like Milwaukee, that whole half of the state. And then the United States District Court for the Western District, or the West District of Wisconsin, which would be Madison on that other side of the state, that side, the west side of the state. Illinois has a Supreme Court. It has 5 appellate courts. The First District Appellate Court is solely Cook County. And then there are 4 others that cover the rest of the state. Peoria, Tazewell, Woodford, McLean County, Knox County, I don't know if I'm covering where everybody's from, but you get the idea, are in the 4th Appellate District. The 3rd Appellate District is where we used to be until recently. And then there are 24 circuit courts. Most of those are made up by multiple counties in one circuit, except again up by Chicago and the collar counties. So Peoria is an example. It's Peoria County, Tazewell County, Stark County, Putnam County, and Marshall County make up the 10th Judicial Circuit. Woodford County and McLean County are in the 11th Judicial Circuit. Knox County is in the 9th. All right, so we have in the southern or central and southern parts of the states, or south of Cook County, we have multiple counties that make up a circuit. And that's why you will see, if you file a case in Peoria County, the jurisdiction is listed on that document as in the Circuit Court of Peoria County, 10th Judicial Circuit is the proper name for that court. If you file it across the river in Tazewell County, it's in the Circuit Court of Tazewell County, 10th Judicial Circuit. You'll get more into that in legal research. You always have to check which court has jurisdiction over the location and subject matter of your case, the venue. And double check because boundaries change occasionally. And that's one of the reasons I had you go to the Illinois Courts website and surf around there, because that is where you would go to double check. Now, working in this region, it's more likely than not that you are going to be somehow involved in something that is out in one of the areas in the central region of the state in which there may be multiple boundaries for circuits and possibly appellate court districts. So if you're dealing with the state courts, you really have to use this resource. Go to the Illinois Courts page. Double check which court is appropriate for filing your initial case or an appeal. So be sure to spend some time on and save that page as a bookmark. Now, small or large counties, there is a civil or criminal side of the courthouse. Now, in reality, there are some small counties that only have one courtroom in their courthouse. So I guess they may not have a side, but even in some of the smaller courthouses, they have 2 courtrooms. You may only have one judge that hears everything. They may hear traffic court, divorce court, criminal court, felonies, misdemeanors. So what do I mean by a civil and criminal side of the courthouse? Well, that's the dividing line for the types of things that people bring to the courts to be decided. On the civil side, we're looking to have something addressed that does not include or concern life or liberty, punishment, or crime. On the civil side of the courthouse, our burden of proof is traditionally preponderance of the evidence, which if you would take your hands and you would hold them out to the sides, to your right and to your left, and open your palms to the sky. If you would tip your left hand down just a little bit from level, and your right hand up just a little bit from level, that's preponderance of the evidence. It's just a little bit. The scales of justice tipped just a little bit. That's sufficient to win your case at the civil side of the courthouse. On the criminal side of the courthouse, we are concerned with life or liberty. Now, we've done away with the death penalty in Illinois a long time ago, so we're not concerned with someone's life in Illinois, but that's not true at the federal level or the several states. But we are concerned about penalties and punishment. And it's not two citizens going against each other, it's the people of the state of Illinois, the government going after someone who committed a harm upon the public. Now, they may have had an individual victim, a person who is a victim. But it is, to be clear, in a criminal case, the people of the state of Illinois versus the defendant on behalf of the people of the state of Illinois. And the case is intended to protect the public. On the civil side of the courthouse, we have things like divorces and family law, custody, child support. We have auto accident cases, all the stuff you see the people advertising on TV about how well they can represent you if you're injured or harmed. And an auto accident, a work accident, a nursing home accident, something like that. Typically, cases brought against insurance companies as the pot of money, but between two individuals generally. It's private people seeking compensation. It could be probate matters. Someone dies and you need the court to help settle their property. It can be business disputes, breach of contract. Contract issues between two businesses. On the criminal side, we have misdemeanors and we have felonies. Typically, the traffic court's located on the criminal side of the courthouse. Traffic court is not criminal, but pseudo-criminal, even up through DUI, where someone kills somebody while DUI. And then we have those ancillary things, or not ancillary things, the things that are in the middle that don't really fit directly and may appear more criminal and have civil components, like domestic violence, which has orders of protection attached to that, abuse and neglect, juvenile, which is typically on the criminal side of the courthouse. That's what I'm talking about when I say there's a civil and criminal side of the courthouse. There are different things that are handled that have different burdens of proof. I covered the burden of proof, preponderance of the evidence. Beyond a reasonable doubt is you have those hands up, palms to the sky, and a guilty is your right hand's all the way up as far as you can reach, and your left hand is as far down as you can go beyond a reasonable doubt. That's what the scale of justice has to be tipped towards. Criminal and civil side of the courthouse. That's what I have for this week, folks. We're 3 weeks in, 5 weeks to go. If you need me, you know where to find me.